the resolutions stand as a strong roadmap if we use them. They call for parties and states to comply with the laws of war, no impunity for rape and war crimes. Most importantly, in 2008, they found that rape is being used in some conflicts as a prohibited tactic of war under the laws of war. This means that women who are subjected not just to rape in conflict, but rape when it's used as a tactic, should have 2 bites at the apple of accountability. One, the crimes of rape, and second, they've been victimized by the use of an unlawful weapon in which they may not have to go through the same difficult elements of proving a case. It would be different when it's the use of unlawful weapons. You don't see the chemical weapons used in Syria requiring every victim to give testimony before Syria is held accountable. Finally, and I take some credit for this, along with my wonderful staff, in 2013, in the last resolution of the Security Council, Resolution 2122, the Security Council called for women raped in armed conflict to be provided abortions as part of their non-discriminatory medical care. Now, who would have thought of that? The problem is that the Security Council has allowed this implementation to obscure the rights of women by letting implementation plans by states and the UN mix up human rights law and national law and international law, rather dumbing down the special protected rights of women in conflict, which have status above national law. And for a medical service like abortion, that's critical, because if you relegated women in war to national laws, the national laws would preclude them from receiving a necessary and life-saving medical treatment. In fact, when I examined the implementation plans for that chapter in the book that's being passed out, I was befuddled and amazed. I mean, they're very complicated. They talk in terms like matrices and modules and indicators and swaps and, 67 pages of what everybody's going to be doing on this, which really boils down to really business as usual. I mean, out of 67 pages of what every agency of the security of the UN body was going to do about implementing the resolutions, 3 mention the Geneva Conventions. States are ordered by the Council to come up with action plans how they're going to implement these resolutions, and out of, I think there's 43 now, only 4 even mention international humanitarian law. So in a way, the Security Council resolutions have become sort of the means by which states are addressing the problem, which takes states off the hook because they have stronger obligations to take all actions within their means, individually and collectively, in the absence of these resolutions. So, number one, when the Security Council reviews these resolutions, which they're going to do this year in the next phase, it's important that they make clear that these resolutions require states and UN bodies to differentiate their duties under international humanitarian law and women protected by international humanitarian law from their duties, their legal duties towards situations in post-conflict and in peacekeeping. The Council must make clear that the duties of states and UN entities are to respect and ensure respect for international humanitarian law in all circumstances, irrespective of state laws. And they must be prohibited from conflating the rights of women under international humanitarian law with the other legal regimes that are part of implementing these resolutions. States must have to be accountable for being rape-using states, just like states have to comply with resolutions on, like I mentioned, North Korea, or in the case of Syria, stopping chemical weapons as unlawful weapons of war. This advances not only women's rights in this situation, but the entire responsibility to protect doctrine, which is a critical and emerging doctrine in international law in which states acknowledge their duties to help victims of genocide or mass atrocity when their own states are either committing those violations or standing by and letting them be committed. Under this kind of new prohibition or new mandate of the Council, states would have to put teeth into their wimpy 1325 action plans. They'd have to live up to their duties and say what they're doing that's within their means, and that's the legal standard, to stop the breaches. For example, states that are members of the ICC could make pledges that they'd make every effort possible to refer another member who's a rape-using state to the International Criminal Court. That would be a concrete affirmative step. That is not the kind of step that's in any action plan or has been in the last 15 years. Now, I want to give a couple examples of what it would really mean if the Geneva Conventions were looked at through the lens of women, and that was part of how the Security Council enforced these resolutions. First of all, women raped in war suffer the kinds of injuries, disability, and rape that's unlike anything outside of conflict. Over 80% and sometimes higher of the rapes in war are mass rapes. Over half are to children under 18. Most are accompanied by horrible mutilations. Also, which I think is not really known, women are raped to death, and this is not a statistic anyone collects. In the genocide of Rwanda, 275,000, or 83% of all Tutsi women who were killed were raped to death. And I don't mean later by pregnancy or AIDS, but literally rape, including using the penis, using guns, using glass. Rape was the instrument of death. But these deaths are not counted under the laws of war as battlefield casualties. Battlefield casualties are conventional weapons, usually shot by male combatants against other male combatants, and there can be civilians, but those are the ones that are caught in the middle. It takes 25 battlefield casualties to trigger the application of international humanitarian law in a situation of armed conflict. I mean, that's a rough guideline used by countries. So raping women to death as part of winning a war would not even trigger international humanitarian law. If you ask any wartime statistical person how many people were killed with explosives, conventional weapons, how many dum-dum bullets, they could tell you. If you ask how many women were raped to death directly in armed conflict, no one could answer that question. That's an example of discrimination under the laws of war. All persons protected by the laws of war, the original purpose of the Geneva Conventions was that all people protected, soldiers who are wounded, or all civilians wounded and sick, and that phrase is a very broad one, not in the usual sense of the term, are entitled to medical care that advance their health or relieve their suffering. The worst thing that can happen to a young girl or woman raped in war, and it happens all the time, every day as we're sitting here, is to get pregnant and be forced to bear the child of their rapists. This is happening every day because no countries are enforcing the Geneva Convention's rights of those women to get the medical care they need. I would say a large part of the fault of that is the fact that the US puts an anti-abortion ban on all its humanitarian aid, which funds nearly all, goes to medical care in all 25 armed conflicts in some form or another, whether it's one going through the Red Cross or going through the UN. Nevertheless, the US ban frames the medical protocols, and this causes this situation of the breach. Independent of that breach, however, other countries could step up and ensure that women have this right. And this is critical to save lives. I mean, more women die from the forced pregnancies from rape than any of the 111 civilians who died from the use of the chemical weapons in Syria, yet you never hear about this population where the deaths, once the torture victim goes for medical care, are absolutely preventable. Second, Rape is used in different ways in war because it's always been in war. It's been as a trophy. It's been seen as a side effect. It's seen as hurting people's property. But it's really, in today's armed conflict, used as a deliberate tactic of war, as that term is defined under the laws of war. And in fact, both the United Nations and the Red Cross have said rape is a tactic of war under the laws of war and unlawful if it follows certain circumstances, like there's some order that it's done in a pattern, and so forth. The Security Council has endorsed this, but no states have amended their laws of war to include rape as an unlawful weapon, even though they have other unlawful weapons they would never use, like the U.S. has starvations prohibited during war, laser weapons are prohibited during war, dum-dum weapons, but up to this day, no one has recognized that the use of rape is unlawful. Except last summer, where I'm proud to report that the United Kingdom was the first country to say that rape in war is always a crime, a war crime. But if it's used as a tactic of war, it's an additional and separate war crime for which states can be held accountable. Now, this would be an enormous breakthrough for women. First of all, it would hold states accountable and start delinking reparations from actual crimes. And it would also provide an extra avenue for prosecutors. If you couldn't find, individuals to testify, and this would have to be worked out. Boko Haram is engaging in murder and war crimes in their investigation. This is a preliminary conclusion. So far, so good. But why haven't they mentioned genocide? The abduction of the schoolgirls, converting them and marrying them off, is exactly the act of genocide defined in the Genocide Convention but never prosecuted for, called the forcible transfer of children. And under this was taking children, forcing them to then have babies and erase the nationality or the ethnicity. This happened to the Armenians, to the Aboriginals. This is what's happening to the Christian schoolgirls and the women in ISIS. So this is an example of an international protection designed for women and children that isn't being used now, and that fits the crime perfectly and in fact is admitted by the perpetrators. Further, once there's a crime of genocide suspected, states and the UN have to do more than they're doing now. And that's another example of how true enforcement could change for women. So in conclusion, I was asked the other day, well, what kind of radical suggestions would I have for the Security Council when it comes up to review the laws of war and the Security Council resolutions on women, peace, and security, including equality? And to me, the answer was simple. Just start enforcing the law, including the right to non-discrimination in each and every provision of the laws of war. Now, this doesn't ignore the rights of women post-conflict or in peacekeeping situation, but I think it's an affirmative action push to putting those rights into that situation. Once women in conflict are entitled to abortions under IHL, it's going to create a norm change that's going to be difficult to change post-conflict. It's time for the Geneva Conventions to work for women, not against them. It's time for all laws, in fact, to work for women and not against them. We are at a pivotal point for global security and for women. The Security Council is the most powerful entity in the world. Women need to control its agenda. Thank you.